Close to this Eric Greitens story, and that's, of course, Al Watkins, who is the attorney for the ex-husband of the ex-mistress of the governor that was indicted yesterday here in Missouri. Al Watkins, welcome back to the show.
Thank you very much, and I'm pleased to be back.
Are you satisfied with this?
Well, you know, whether I'm satisfied or not is irrelevant. I think that justice is commencing the dance, and you've got a circuit attorney who has done what she needs to do. An indictment has been handed up, and now it's the opportunity of Lady Justice to take the dance floor. Sometimes that's a cumbersome and ugly process to watch, but we have to be respectful of the reality that our governor, who is now a criminally accused defendant in a felony case, has the very same rights that every other criminal defendant has, and that includes the right to be presumed innocent until such time as he is proven guilty beyond a reasonable doubt. He has a right to confront his accusers. And quite frankly, we're going to have a bit of a walk down this long aisle until such time as a judge or a jury adjudicates the outcome of this case. We have to be patient.
All right, so a couple of questions here, and that is, did we learn yesterday, I know the allegation from your client that there was a picture taken. Did Eric Greitens' defense team, with what Ed Dowd say, confirm there is a picture?
It appears to do so. There was a motion to dismiss filed yesterday, which was relatively curious given the nature of the case. And the defense in the motion to dismiss is, look, you know, the photograph thing, disregard that. I mean, look, the woman had no reasonable expectation of privacy. What's the big deal? In effect, that's what it appeared to me to be the gist of the argument in the motion to dismiss. So now, despite the fact that at the initial outset of the disclosure of this dalliance, when the governor said, no, I didn't take any photograph, and then despite the fact that that response kind of morphed into a non-response where any time he was asked as to whether or not a photo was taken, he responded with, I've answered all the questions about this that I will. Everything was consensual. And now the attorneys are saying, well, you know, look, the statute is not intended to apply to a situation like this because it was consensual sex, and therefore there was no reasonable expectation of privacy, which would tend to indicate that there is an acknowledgement that a photograph was taken.
Yeah. Also, Jim Bennett said to the Post-Dispatch in January 11th in the newspaper that there was no picture. So his lawyers were saying that in the beginning. Now his lawyers aren't saying that now. So
yeah, there's a very important lesson to learn there. You know, when you get the burning sensation, when you have a flow, it's time to go to the urologist. And when you do that, you've got to be honest with your urologist, or, interestingly, the burning sensation will continue. And it's the same thing with lawyers. You have to be forthcoming with your lawyers.
All right. Can we assume that KS testified, or at least was working with the prosecutor in the city?
So I am not in a position to, nor would it be appropriate for me to comment about the grand jury or anything that the grand jury may have heard or may not have heard. And in fact, there are actually statutes which preclude people from talking about that. I can tell you, in general, it is virtually impossible to procure an indictment of this nature or to move forward with a prosecution in a case of this nature without the cooperation of the victim.
Gotcha. So I'm assuming then you can't tell us, even if you knew, who that third witness was in the indictment.
Again, it would be really inappropriate for me to cross over the threshold and into the domain of the grand jury and what it may or may not have heard or had introduced to it.
Can I ask you what your client, the ex-husband, thinks about what has transpired over the last 24 hours?
Sure, yeah, and that's a really good question. It's important to know, and I'm going to say this as brazenly and as candidly as possible. My client doesn't give a rat's rear end about whether the governor remains governor, whether he steps down, whether he's impeached, whether he's indicted, whether case is dismissed, whether he's convicted, whether he's acquitted. He doesn't care. His goal and objective is to protect the interests of his family. And part of that family is his former spouse, the mother of his children with whom he co-parents. He really, genuinely just wants to get this guy who decimated his marriage and a circle of friends and extended family members in his rearview mirror. He wants him behind him, not continually serving as an anvil over his head.
What do you make of the news that the governor said it was some type of liberal prosecutor and then reached out for a secret meeting?
Yeah, I think that's the functional equivalent of Helen Keller with a rake on a golf course. And I don't mean to be derogatory to those who may be impaired from a vision or hearing standpoint. We all have our own weaknesses, flaws, and shortcomings. But the fact of the matter is that is ridiculous. The circuit attorney actually appears to have made every effort not to simply issue charges, but rather to do that which is necessary to process this evidence in a fashion which gave rise to individuals who are members of the public, who are jurors, to make that decision. So it wasn't made the decision was not made by the prosecutor. So on one hand, you have the governor saying this is a political maneuver, and on the other hand, saying, oh, by the way, let me whisper through an indirect party, hey, can we get together so I can just tell you why it is that really you don't want to do what you're doing?
Lastly, Al Watkins, what do you think of Ed Dowd's statement that these charges really were meant for and written for peeping Toms and not a consensual affair?
Well, first of all, let me say this about Ed Dowd. He's a great attorney. He's a great man. I consider him a friend. I also consider him to be an extraordinarily capable adjudicator. He is an advocate for his client, and he will step in front of a bus for his client as any good attorney would. That being said, I can tell you after 3+ decades in this practice of law, I have had the privilege of representing a number of individuals who have been charged under this very statute. And when you are trying to assert that this statute does not apply to the fact situation that's involved here, I would respectfully suggest that is, at best, highly erroneous.
Al Watkins, attorney for the ex-husband of the woman who was having the affair with Governor Greitens. Al, you're always welcome here. Thanks for checking in.